Everyone. Duena Boswell Shell here with the Boswell Law Firm. And it is a gorgeous, gorgeous day outside, so I hope everybody has a chance to get out and enjoy it. I myself got my second COVID vaccination shot today, so far so good. I've had a few friends that have really experienced the worst side effects that they could possibly have with the virus or the vaccine. I'm sorry, and so hopefully things are going to keep going just the way they are. So I'm I'm just excited to have that behind me. And today we are going to talk about the importance of knowing what you need to do when you are a fiduciary. So fiduciaries would be if you're the executor or administrator of an estate, that puts you into what we call fiduciary capacity, because you are basically representing somebody else's interests in property. And so you have a higher degree of a duty to them to make sure that you manage the property like it's supposed to be managed. So, in the case of an estate, if you're the executor, you're going to be the fiduciary, and you are going to owe that duty to every beneficiary or heir that is either named in the will or the state law says is an heir. So, it's a very important job, and it's very important that you do it correctly, so that you don't get in trouble and everybody gets the property that they're entitled to. So, what happens when we have a minor? Well, you can't just give a child that's under 18 a whole lot of property. It's against the Uniform Transfer to Minors Act, and so it has to be managed in some sort of an account. So you can set up a trust, and I always suggest that if you have a minor in your will and your estate planning documents, that you make provisions for a trust in case you have a minor child. You can also establish corporate trusts. You can have custodial accounts. There's several different ways that you can establish an account, but it's something that you're going to have to make sure that whoever is the trustee of those accounts or the custodian of those accounts must keep very good records, and they have to make sure that any investments that they make of the property are good investments, good sound investments. Make sure that if it's real property, that the houses are maintained, and that um, you know mortgages are paid, the insurance are kept up to date, repairs are made. Um, if it is a house, rental income, something that is earning money and not just sitting there and wasting away. So probably the most important thing to know is you can't just go out and sell property that belongs to a minor. So if you are a parent and it's, Lord forbid this never happens, but it does, your child dies and your child has a child. So the your grandchild is the beneficiary if there wasn't a will saying something different. So if you were going to take control of the property, you owe that fiduciary duty to that grandchild to make sure that if you sell the property, that the proceeds from the sale go into an account that is going to earn interest. You can't just take things and give it away. And I see that happen quite often. And it's actually a crime to do that. So if you intentionally go out and sell something and don't maintain the property or the proceeds from selling that, you could actually face some criminal charges. And the degree of the criminal charges depends on the amount of the value. For instance, Class C is simply like a traffic ticket, so it's going to be a fine if it's less than $100. That's not very hard to get up to $100. So if it's between 101 or $100. So Class C, if it's $99 or less, so 100 to 750. You're going to look at a Class B, which is 6 months in jail and up to a $2,000 fine. And that's on top of any kind of restitution that could be put in place. So if you sell a house that's worth, $100,000, then the restitution could be that plus any fines on top of that. A Class A misdemeanor, if it's 750 to 2,500. Actually, it's going to be $2,499. $2,499. You're looking at Class A, which is up to a year in jail and up to a $4,000 fine. And then we start getting into the felonies when you're looking at $2,500 and above. So when I mentioned that $100,000 home that you sold and didn't keep a hold of the proceeds, then you're looking at a third-degree felony. So your time in jail could be substantial, your fines could be substantial, and you're going to have to pay back the restitution. So it's a good idea that if you're in that situation, before you start doing anything with the property, contact an attorney and make sure that you're not doing anything illegal that you could be actually held criminally liable for. And then you can also be held liable in civil courts as well. So it's a dangerous situation to try to figure out and navigate the waters alone. And there are so many very good attorneys out there that can help you through the process and make sure that you are not doing anything wrong that will get yourself in trouble. As always, if you have any questions, you can direct message me through Facebook, or you can send me an email at service@boswelltexaslaw.com, or give us a phone call, and we have a free 15-minute consultation. I'm willing to answer any questions you may have, no obligations. And that number is 832-919-6595. I hope everyone has a great weekend, and we will see you next week.